Professor Baird, as you mentioned in your opening statement, the Federal Priority Act allows receivers in state insurance insolvency cases to be held personally liable if the receiver disperses funds without repaying the federal government first. Bankruptcy cases are specifically exempt from the Federal Priority Act, but the Bankruptcy Code has the procedural protections to ensure the government is repaid. But I guess what we're seeing is the same is not true of insurance insolvency cases, which are largely handled under state law. If we're considering legislation to limit liability for state insurance receivers, what types of procedural safeguards should be in place so that the government does not get skipped over or becoming the first in line when attempting to collect on its claims?
The thing to remember here is that the absence of the kinds of rules we have in bankruptcy for state insurance insolvencies is not a deliberate congressional decision, but rather is an artifact of the way the law has evolved over time. The Federal Priority Act was established first in 1797, and in bankruptcy we've realized that we need to have procedures. Having procedures for state insurance insolvencies would make sense. What you need to make sure of is the government is notified of the state insurance receivership and knows about the procedure, but it's also reasonable that once the government is notified that it has a certain clock that starts to tick, because unless you have clear procedures, you're not going to be in a world in which receivers will feel confident that they can dispense assets and not expose themselves to personal liability. So again, to answer your question directly, the easiest thing to do is simply ensure that there is proper notification to the government and that the technical rules are satisfied. But this shouldn't be a terribly difficult problem.
Thank you. Judge Harner, I'm going to skip around a little bit, but you discuss undue hardship test in your opening statement, and I wanted to focus a little bit on the student loans. So it's been noted that relatively few student loans are discharged in bankruptcy. During your time on the bench, has there been any times when debtors satisfied the undue hardship test, such as that you've ordered discharge under the student loans?
So it's a great question, Chairman. I will say I do not see many student loan cases, and it could be in part. I don't have any empirical data to back me up here, but I will say procedurally, it's difficult for a debtor. They have to commence an adversary proceeding, they have to file a complaint, and then they have to meet what we call the Brenner standard, at least in my circuit, the Fourth Circuit, which incorporates the undue hardship standard you just referenced. I have had one opportunity where I had a 67-year-old woman who had incurred over $500,000 of student loan debt in the hopes of becoming a business executive. She was trying to repay, she was never going to be able to repay that entire amount. Doing the analysis based on the facts that she, representing herself as a pro se debtor, put into evidence, I was able to grant a partial discharge of some of her student loan debt, which was not appealed by the student loan lender, but I could not find under the Brenner standard, even in that situation with an older individual who had only limited time left to work to try to repay her debt, the ability to grant a full discharge.
Thank you. Judge Black, there have been some claims that medium-sized, well-capitalized businesses or small subsidiaries of larger businesses have been using Subchapter 5 to circumvent the creditor protections associated with general Chapter 11 cases. Have you seen any type of behavior that would, in your courtroom, that would suggest that this is actually happening?
No, I really haven't in my court. I've had some cases that may look right out of the gate like a single asset real estate case that probably shouldn't be there. But I have not seen any type of manipulation of insider debt or anything of that nature in the Western District of Virginia that would present itself in the cases that I see. I think the cases that have been presented to me have all been well suited for Subchapter 5. And again, as Judge Harner and some of the other witnesses have pointed out, if there are cases that come before us, we have the ability to do, to prevent shenanigans, for the lack of a better description. We've got the ability to appoint a creditors committee, different avenues are available for the Subchapter 5 trustee to have a different allocation of powers to investigate the debtor's business. So in the cases where I am in Southwest Virginia, I'm not seeing that.
Thank you. I'd yield back.